Hi.
Okay.
Yeah, we'll have her.
Are you Angie?
I am.
Hi, Angie.
Hi.
Hi, Karen.
Hi, Roger.
How you doing?
I'm doing good. I'm glad to see you still here.
We are too.
Yeah. Amazing life of service you've led.
Oh, yeah, there's other reasons why we're glad to still be here.
Yeah, right?
Okay, Karen, have you been to a Board of Equalization prior to this?
I haven't.
Okay, you're here on behalf of Candle LLC.
Correct.
Who's that?
It's a limited liability company, and I'm the managing member of it.
Okay.
I am not a majority interest
It's
in
your
it.
representative.
Yeah, you probably know I've been a CPA for about 30 years, and I actually, this is a client of mine, and so I actually have power of attorney to act on behalf of this organization, but it's mainly a client that I'm representing their best interests.
Okay, the purpose of the Board of Equalization, I'll give you kind of the spiel, is if you've got an assessment that you don't think is accurate, it can't come to an agreement, or what the assessor is required to do each year by statute, so that other entities can set their budgets, is assess everything equally. They call it equalization at current market value all across the state, all across the county. And what they do is they take the sales, compare the appraisal category with those, and come up with a fair market value of what things should sell for on the market as of 2021, because we're always a year behind. If you disagree with that value, we have a hearing in which you have the opportunity to present sales and other evidence of why they're wrong. Taxes are always a byproduct, and everybody wants to talk about them because this does affect them, but that's not relevant to this hearing. So we'll have you present why you think it's wrong along with any supporting evidence. We'll have the assessor present his evidence. We'll make a decision on what we gather in this hearing. It's a quasi-judicial hearing.
Right.
So we have to make it based on the evidence here. If you disagree with that, you'll have 28 days to file an appeal to the state tax appeals who come here in September. It'll be a trial de novo, so you can gather any additional information if you got here and think, oh, I know that's out there, but you haven't got it to present to us. You'll have a chance to go do that and bring it to the state. So first we need to swear everybody in who's going to be, if you raise your hand, it'll be you. Do each of you solemnly swear to the statements you're going to give are the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Okay. All right, Karen, tell us all we have is too high.
Yeah. Yeah.
It wants
Yeah,
it to,
I didn't know
it
what
wants
you
it to
said.
be an ag.
Yeah. And
Okay.
could I just make sure I know, so are you?
Oh,
I'm Brian, yeah, I'm sorry, I'm Brian Reed.
Hi, Brian.
Hi, nice to meet you.
Nice to meet you.
And this is the assessor,
Okay.
Dustin.
Okay. And are these people behind me all assessors too?
They're appraisers, and then there's
I'm
the
the
assessor.
chief deputy.
Yeah.
Okay.
Some of them are new,
Yeah.
so they're here for
I just
training.
feel like it might be hard to, to be.
They're not ganging up their.
Yeah.
No.
Well, I know.
Not.
I know. I've been on city council for City of Amman before, so I understand. But I think it's sometimes difficult to fairly represent if one person is here and then you've got
No, yeah, they
12 people.
they won't be
Yeah.
interjecting.
But then again, I've worked with the IRS long enough to know that you make your best case to the IRS agent, you likely will lose there, and then you have to make your best case to the
How
tax
do you
court.
get them to respond back to you though?
Yeah.
These days. you
Yeah.
know?
Actually, practitioners have a little bit easier time with them, so anyway. So,
Okay, so your main reason is you want these in ag value.
yeah, and I want to just give you a little bit of a background to this piece of property. So this piece of property was a like-kind exchange from ag property in Utah. I just wanted, this is not all that relevant of a document, but I thought I'd give it to you here. And the property was actually down in Payson, Utah. I don't know if you know where the Walmart is.
So this was a 1031?
Yeah, so this is a 1031. Back down where Walmart is now, there's like an LDS temple there. And that was ag property, used to be an onion farm for a lot of years. And the organization, when I was talking to my client, and they were thinking, this organization has a history of farming. They have done onion, they've done sod, and I'm not really familiar with all of their operations. I know they've done pine trees, I know that they've done animals and hay. But anyway, so this was a like-kind exchange from ag property up here to ag property. The reason that they ended up in Idaho was my recommendation. I had listened to enough stories. There are certain communities in Utah that they get very aggressive in what you can and can't do with your property, and they want you to be in planned unit developments and things like this. And so in the course of this discussion, I had just recommended on a professional basis, and because I had experience with government here, I had indicated that in Idaho we still have maintained our property rights here. And we haven't, we have an independent tradition, and we haven't given up our rights to government as much as they have in Utah. So I had basically indicated that they would be able to come up here and have an ag exemption and be pretty much left alone by government. And it's been successful. I think they've been happy with this particular setup that they have here. The reason why I'm here today is to tell you that there's nothing changed in the law, and yet something changed in the property taxes. So we need to understand that I actually have not gone to the client and spoken to him yet. It's my purpose here to find out exactly why it is you guys feel like when nothing has changed in the law or in our situation, why you feel like we should start paying property taxes on this property. It would not be my recommendation to this client to continue to own property if they have to pay taxes on unrealized value. Realize that, and you guys know this, you sit here all the time, but it's not a good investment to pay property taxes on unrealized investments, especially if you're entering a recessionary cycle, which it's my opinion we are entering a recessionary cycle. So what I would like to do here is find out, your reasons for raising property taxes, and then I'll take it back to them. I'm sure they will run it past their inside legal counsel and decide what they want to do after that. But that's what I need to do. I need to find out from you guys why we're raising property taxes when nothing has changed.
We need to find out from these guys why they did it.
And the other thing that I'd like to also find out, because I'm sure Lee will ask me this, is we bought this from Skidmore's, and I have some history with Skidmore's. I was actually a number of years ago when Comora was having water problems, and water and agriculture, they go hand in hand. So I got on the board for Comora, and I personally stopped development in Comora until Skidmore signed an agreement that I and Royce Lee hashed out for 5 hours in his attorney's office to stop the water problems in Comora. Okay, and then I was also instrumental in getting the DEQ funding to build the well up there, and the storage, the water storage we have there.
So you're dealing with 4 parcels?
Yeah, 4 parcels.
These 4?
Uh-huh.
Okay, what?
Contiguous, 7 acres. Yeah.
2, 5, yeah, about 7 acres.
And so in the response here, knowing the Skidmore's enough to know that they are a development company, whereas Kendall is not. I'd also like to know if we could get a response here. If not, we can get through a public document request. If Skidmore's, who's a development company, is maintaining agricultural exemptions up there. I would like to understand why there would be a difference between Skidmore's maintaining agricultural exemptions and Kendall not, so.
Okay, well, let's deal with these first, and what changed in these was, well, I can speculate, but I want to hear, were they under the ag exemption?
They were,
They
so
were.
in air, because Skidmore had applied for ag exemption for all of those parcels prior to being platted individually, and even after being platted individually, he was receiving that ag exemption. He has been to a hearing in years past and expressed that they are making an effort to grow or develop it it was dedicated to agricultural purposes. As lots sold in air, a lot of those lots retained that agriculture exemption, not just in Kamoroloma, but in a number of divisions. As we've gone through our reappraisal process, Kamoroloma was up for review this year, and as we have in past, as we go through and update them, that error was essentially corrected because it is no longer actively devoted to ag. It was then moved into its full value, full market value.
Okay, give us the definition of actively devoted in ag.
So there are two ways you can get that agricultural exemption. One, actively devoted to agricultural use and over 5 acres, or actively devoted to agricultural use, and if it's under 5 acres or under, provide $1,000 of income or more, proof of $1,000 of income or more. So that could be grazing, that could be growing a crop. We don't judge the quality of the farmer if there's an attempt being made to grow.
Wild grasslands. Yeah.
Is wild grassland a legitimate farming thing?
If it's being grazed, we don't have,
grazed.
yeah.
So we, this particular property has been actively discussed as grazing for horses. There's just been an issue of building a fence that's kept us.
You say it's been discussed with whom?
With some property owners, horses that are currently being housed in Alpine. And the owners are here in Idaho Falls and would like to move their horses here.
But in the 2019 or 2021 tax year, it was just being discussed but not used for grazing, correct?
Correct. But the business model of this particular company that owns it, and excuse me, it is Kendall that owns it, but you know, they're one of the members of Kendall. They actually don't, I mean, they don't actively farm quite a bit of their properties, but they always maintain the rights to be able to farm. And all their investments are all agriculture. They don't have any development motives. They've never developed. There's no history of developing. It's always just agriculture.
But I think what we need is some evidence that it's being used for the definition of agriculture under the statute.
I mean, this was actually discussed with the assessor's office prior to this, and I was told, and it was actually part of the decisions that we used to make this purchase, that choosing to let land stay vacant and have the opportunity to, you know, so that it stays in farming, so you have the opportunity to farm it, is legitimate. I was told that by prior assessors.
Assessors or appraisers?
I'm sorry, I actually don't
There's
know.
one assessor.
Yeah.
He hires appraisers.
I actually, I probably could go back and find my notes on who I discussed it with, but I can't tell you right now who it was.
Taking a legal opinion from an appraiser is kind of like taking an opinion from the IRS over the phone, which you understand. Is that going to stand up as a defense?
But I think it was the assessor's office that I spoke to before.
Well, I know.
Yeah.
I mean, kind of the same thing.
Yeah.
You call in the IRS helpline, they say you do this, you do it, send it in, and it's wrong. Do they change it because you said I've talked to somebody on the phone?
Well, I will tell you that if you recorded it, and you can rely on their advice. Yeah.
Right.
It's the same thing. If one of my clients make a decision and they relied on my advice, then the IRS will, the fact that they sought out, because I have standing with the IRS, they will take it into account to rely on the advice of the CPA. So,
Even in an instance, if it was an appraiser or the assessor at the time, if it was in regards to these properties specifically, it may receive a different answer than 7 acres of acreage sitting in a field. I'm not saying that necessarily makes a difference, but it may garner a different response from the appraiser or the assessor at the time. If there was a blanket question of, if I was to purchase land, under the assumption that it may be out in, 7, 20, 15, whatever the acreage may be, in an agricultural farm, as opposed to 7 acres lying in a subdivision. Again, I'm not saying that one is any more correct than the other, but it may have received a different answer from the appraiser at that time.
but all of these decisions, all of these conversations are had before a business decision's made, okay? And for us to all of a sudden change how we're gonna apply the law at this point, to me, we talked to, when I was on the Ammon City Council, we talked to our attorney quite a bit. And we were always given the advice that if you've always let that stand and you've always done it that way, you don't change it. Our attorneys are always calling that a taking. So the reality is we did talk to the assessor's office before, and I'll go and check and make sure, but I'm almost certain it's the assessor's office. We did talk, even here in this escrow, you can see there's information here, the next to the last paragraph. Parties acknowledge that the property transferred has not been split out as separate tax parcels. This was all taken into account to make this business decision. Nothing's changed that I know of. We made a business decision based on all of the advice that we sought out at the time. It seems to me that the only thing that's changed are the people that maybe are interpreting what the law says, which I don't know if, and the commissioners will have to make a decision on that. I don't know if you feel like you need to represent the assessor's office or the people. But, is that a valid reason to make a change just because the people that are interpreting the law have changed? The law hasn't changed.
To answer, I think we need to represent the law. That's what we're doing. We're not representing you or the assessor's office. We're just trying to represent the statute.
But the law hasn't changed. Yeah.
The issue is, and correct me if I'm wrong, but when it comes to assessments, they're required by law to reevaluate on a regular basis to make sure there's fair market value and equalization. Whereas if you're dealing with planning and zoning issues or that, I can understand an attorney saying, you gotta be careful of a taking. This is a different situation where it has to, by statute, be reevaluated continually to make sure it's equalized.
But what I'm saying is where we've had a prior assessor's office, and I think, I'm not sure, but we can investigate it. I think that you will also see that there's other property up there that's not being farmed, that has agriculture.
But we don't know, so it's not relevant here. We're talking about these. Now the question, was this on the 5-year?
Yes,
Where you physically went up every
Yes.
5 years and view it?
yes,
And did you drive by this?
Yes.
And it was your opinion that it wasn't being used as farming and that's why you
Correct.
changed it?
correct. And
Okay.
the cells that you see, the parcel cells that you see off over here is, that's actually been developed. There's actual roads.
That was my next question. When
Yeah.
was, because that.
The aerial is
Yeah, that's-
outdated, but
Yeah, that's all been, there's roads in there, there's water, there's, everything's there. I actually have building permits to build homes on there.
So those are new building
Yeah.
permits that used to be in Skidmore's larger
Yep.
parcel that have been
Yep.
picked off to leave these smaller parcels.
Yes,
Because before it was considered a bigger unit that could be viably farmed.
right.
Okay.
Well, and then also, if you look around her lots that she has, it's all been developed except for there, and the lot next to hers. But even the lot next to that's being developed.
And that's been developed within the last 5 years
Yes.
when you saw it before
Yes.
and made the interpretation?
There's houses that I'm putting on the rolls for 2022 right there.
So help me understand how development around us affects.
It shrinks the size and changes, well, you've changed ownership because it all used to be the same ownership with Skidmore. And then as he sells them off, it changes the size, which does have an effect on the viability of farming. You know, if you have 20 of these lots while you're in the process of developing, you can still farm it. If you carve off and put roads in between them, it makes it harder to be viable, but
So I can see that for Skidmore's, but how does that affect Kendall?
well, when he sells your 4 parcels, you have to meet the requirements showing that it's actively devoted to ag. You know, you're over the 5.
But like I said before, I've had an assessor tell me that as long as it's available for agriculture, we didn't particularly have to be farming.
And I can't address that
Can't
because
either.
that's not the,
Yeah. I
even the
can't either.
Supreme Court changes precedent.
Really?
Yeah.
Well, I know that, but that's really your,
No, I mean, it's you know, we can't rely on, because you could look at that back row and some of them are fairly new and they could give you an interpretation that you're relying on that's just not correct.
and I know because you have the assessor sitting here and you are trying to support him. But had the assessor
No.
from 5 years ago been sitting here.
Let me clear that up again. Like Brian said, we're trying to make sure the law is being interpreted. So let's stay focused on, is this actively devoted in ag after the 5-year review?
Yeah, but like I said, if there was an assessor sitting here that said, I had told her that as long as it's available for agriculture, she doesn't have to be actively farming it, I think he would be trying to support that opinion.
I don't
No,
think so.
I would err against it, because he would be wrong.
Okay, so then why 5 years ago didn't this happen?
I don't think anybody appealed it 5 years ago.
How, do you know when you guys took ownership of the property?
Yeah, so 5 years ago, the same thing happened, that we also got a similar, and this is kind of a side note, but it is nice to have somebody mention it to you before you just get the bill in the mail. But anyway,
5
the same
years.
thing happened. I called the
Yeah, it was
assessor's
changed.
office, and we had probably a 30-minute discussion.
Okay.
And I said, explain to me what's happened here. And he took a look at it and he said, that's been a mistake. He said, originally, I thought it was under 5 acres and so you needed to be farming it. But I can see now there's over 5 acres, which means that it has to be available to be farmed, but you don't have to be farming it. And he explained the law to me, we had a discussion, and he said, I will make sure that's changed.
But it never came to us, and we're the
No,
appeals
the
court, so-
assessor.
I know.
Yeah.
But how many did you have this year that went to the assessor that never came to us, that you've talked and made adjustments? We may or may not have agreed with 100, what would you say, 120?
We currently have 213 that protested. We had, well
But they
over
worked
500
through, but
that,
these are the ones that come to us, and that's the ones, we don't get involved in those because they have the opportunity to change those before the deadline.
Do you guys, do your records go back 5 years? Can you see that the assessment was raised and then the assessor's office gave the exemption back?
I'm pretty sure we have it somewhere.
Yeah.
if there was a
And-
correction made
Mhm.
after you received your notice, then yes.
Okay,
If the correction was made prior to the notices going out, then
Probably
it
not.
wouldn't.
it was made after the notices went out, so I could get that with a public request. or
But we
public
don't
record.
have that today, correct?
Right, but I can get that with the public records
Okay.
request. Okay.
You could really just call us, you don't, I mean, if you,
Yeah.
you could go that route,
Well,
you could do that, but.
Yeah, with an explanation, because I've dealt with these for quite a few years, as you graciously pointed out, and I've been here forever. So we do understand it, but based on the evidence we have now, this is where the de novo part comes out. If you could bring up the evidence, but we don't have it to review, we have to look at it on the change, on the observation of how it's currently being used. And with that, I would recommend we uphold this, and then,
I would second that.
okay. So we're gonna uphold the assessors. We'll have Kayla, along with the letter of our decision and this with the signed decision, we'll send a form where you can file for an appeal on the state. They do meet here in usually September. Same process, 3 different people from the state, and it is a de novo trial. So you can gather up all that information that you didn't probably understand that you would need to bring here, and you can bring that there and make your argument.
Okay.
Okay?
And this is for you. This was what I brought.
Oh, okay, yeah, I was gonna ask you then. And then, Angie, I do want you to look up for this,
Research it.
yeah, that, because the same thing happened 5 years ago, and the assessor made a different call on it.
Okay.
So I'd like you to find that for me.
Okay.
Yeah, and you're welcome to
Would
do
you
this
like me to-
official request, but we can, you don't need to, we can do that for you. You don't have to.
Yeah, if you want me to do whatever you want me to do for requests, yeah.
Do you want me to email it to you? Do you want me to come over now and I can?
I can come over now, and, yeah, let's do that, because I'm going to ask you also the.
Okay, thanks.